I'll give you an example. So how long will the governor have to take for that? He's the governor who doesn't have to act on the aid and advice of the Council of Ministers. He doesn't consult the union government because he has no right to consult the union government.
So in sending it to the president, there would be an advice of the Council of Ministers?
No. That's not my argument.
We just wanted to know.
Well, that's the argument of Dr.
Speak that as to whether it is to be sent to the president or not.
No, correct. So your lordships will have to come to the conclusion to decide against me that sovereign act of the legislature need not be implemented by the executive. He can withhold it. So for the first time in the history of constitutional law in this country, your lordships would hold that the will of the people need not be implemented because the governor chooses to withhold the bill. It's a proposition, Malats, which is unaccepted under any principle of constitutional law. It cannot be. Why, Malats? Now let me give your lordships why. If you look at the theme of the Constitution throughout, in respect of the executive chapter, Malats, in relation to states, or the executive chapter in relation to union, you will find that the executive at no stage has any legislative power. If it comes to the executive in the union, Malats, the president will act on the aid and advice of the Council of Ministers. The president has no individual function. When it comes to the state, Malats, the governor will act on the aid and advice of the Council of Ministers. The governor has no individual function. If at all, the governor has two functions, Malats, which are somewhat different under the Constitution itself, which is 356. But that's a recommendatory function. It's not a decisive function. The governor will recommend that the functioning of the state is such that that cannot function under the provisions of the Constitution. Who decides? The government of India. Who decides finally whether that's right or wrong? Your lordships. So you have to address that question first, Malats. Let's forget about case law. Fundamental constitutional law. 356 is one such power. 161 is grant of pardon, again, exercised on the aid and advice of the Council of Ministers. And 311(2) is another power. 311(2). Inquiry not necessary to dismiss a government servant because of the satisfaction of the governor. Again, on the aid and advice. Give me one provision in this Constitution, one, that allows the governor to exercise any power which thwarts the legislation. We'll come to timelines later, but at the moment, I'm not concerned with it. So you have in 200, in a part of 200, a power to allow the executive, namely the governor, who doesn't have to act on the aid and advice of the Council of Ministers. He doesn't consult the union government because he has no right to consult the union government, but he will just withhold the bill. Such a proposition is untenable from any standpoint. Point number one.
Two, what choices does he have? Let's now assume, Malats, in my favor.
I assumed against myself, Malats, and made my point. Let's assume in my favor that he has no power to withhold. Where do we go from here? He then has to either send it back. Now, Dr. Singhi made 3 alternative propositions on that, but I'll not go into that for the moment. He has one possibility to send it back to say that you reconsider the bill or you pass the bill with certain amendments. That's what's reflected in the first proviso. Right, Mal? And that he has to do as soon as possible.
Or he sends it to the president for his consideration. That president means the government of India.
Not president in his personal capacity or her personal capacity. That's the only two options he has. Now, my lords, if he exercises the first option, namely he sends it back, let's assume he exercises that option, he has to do it when? As soon as possible. My lords, please reflect on the word possible. It's not just soon. What can a governor have an impediment on not to consider the bill forthwith? He has no impediment. He's holding a gubernatorial office. The will of the legislature is reflected in that bill has come to him. Certain DA allowances are to be given to somebody, or that would be a money bill. But if it's a non-money bill, some in the field of education, something has to be done. In the area of reservation, as your lordship knows, under the Right to Education Act, and these are state acts now, you can reserve for certain categories of individuals. Supposing the government wants that children or orphans should also be included in the reserved category. Children or orphans. I'll give an example. So how long will the governor have to take for that? When you say as soon as possible, what would be impossible for the governor to hold it back? That too, your lordships will have to consider. Forget about the timeline for the moment, Mullahs. Just look at the words of the Constitution. Timelines will come later, Mullahs. Let's look at the other scenario. That the matter is sent to the president for consideration. Now, what did the president do? As soon as possible doesn't apply to him.
So in sending it to the president, there would be an advice of the Council of Ministers?
No. That's not my argument.
We just wanted to know.
Well, that's the argument of Dr.
State that as to whether it is to be sent to the president or not.
No, correct. I'll tell your lordships.
Yes.
I'll tell your lordships. What will happen in the process is that he feels that this may be repugnant.
Therefore, he is applying his mind.
He has to, that's not my, I'm not following Dr. Singhvi's argument there. He has to apply his mind.
So deal with the aid and advise aspect of it first.
I'm sorry?
Aid and advise aspect of it, and also the aspect relating to discretion.
I'll come to
That's
this.
the governor first, because after answering that question, then the second issue will arise.
Yes, yes.
Since he has absolutely no discretion at all.
As far as the aid and advice is concerned, when it comes to the right of the governor to send it back, there is inherent evidence by reading the provision itself that he does in his capacity as governor, feeling that it might be repugnant to a central legislation.
Takes his own call.
That's my
That's not based on aid and advice.
It can't possibly be. It can't possibly be.